Welcome back. You're watching eNCA and this is Today. It's been yet another dramatic week in the Senzo Meyiwa murder trial, with Tumelo Madlala leaving the witness box, finally leaving in tears. Madlala was in the house when the soccer star was shot and killed. He faced a grilling by the defense, who have accused him of being an unreliable witness. Meanwhile, on the sidelines of the trial, lawyer for accused 1 to 4 has appealed to the public to donate funds so he can continue representing his clients. To unpack the latest developments, I'm joined by eNCA's Silindelo Masikane and legal experts Melusi, Xulu and Elton, Hart to take the conversation forward. Good afternoon to all of you. There's a lot to reflect on in as far as this trial is concerned, and it is appropriate that we should do this because so much happens in a week such that we need to sort of locate people and recenter everyone and come back to, despite everything that has happened, what is the core of what has happened and transpired in the last few days. So, Silindelo, let's start with you then, giving us a sense of the highlights. It continued to be Tumelo Madlala in the witness box, but being cross-examined.
Yeah, quite a heated week, another dramatic week in the North Gauteng High Court, where we resumed the November sitting with the cross-examination of Tumelo Madlala. Many key moments, in fact, that took place this week in terms of the defense really poking holes in the testimony of Tumelo Madlala, picking up inconsistencies between what he said in several statements, as well as his evidence in chief in the court itself, questions around what he saw, his doc identification, and of course a heated exchange between Maumela as well as the defense for accused 1 to 4. The defense seems to be quite adamant that the state's case against their clients is weak, and what we saw this week was Judge Maumela as well as Tobane getting into it. It seemed Judge Maumela really wanting to stamp his authority inside that courtroom. Let's just take a listen to that particular moment.
If the court allows me to finish.
No, I'm not allowing you to repeat. I'm saying it can.
No, I'm not repeating, Your Lordship.
That question is not going to answer.
No, I'm not saying he must answer the question. I'm replying to the objection. For whether he answers the question is something else. The court will make a ruling. Let me finish my submission to the state.
No need to finish it. Go to another question.
The Lordship is detecting to me now.
Yes.
I can't. It's not procedural for the court for me. I want to reply.
I am saying go to another question.
No, I'm not going to another question. I'm not asking him to answer the question.
If you don't have another question, sit down.
No.
You are not going to answer.
Your Lordship, you cannot tell me to sit down. Your Lordship.
If you don't have another question.
Who said that I don't have another question?
Yeah. Then ask another question.
Your Lordship. Your Lordship.
Don't do that to me. What are you doing to me?
I'm saying, Your Lordship, I'm trying to answer to the. I want to reply.
Why must you repeat it?
Yes, I have a reason why.
What conduct is that?
I'm saying, Your Lordship, I want to reply.
Why
May the court allow me to reply?
Melusi, Elton, let me throw this straight to you. Maybe let me start with you, Melusi. I'm a student of law, far from graduating. I've never seen anything like this. I've been in court many a times, covering court cases as a journalist. I've never seen where the script is flipped. Basically, you have counsel warning and admonishing the presiding officer. Melusi, have you ever seen anything like this?
I've never seen anything like this. The behavior of or the conduct of legal practitioners in courts, we are expected to be respectful to the judicial officers. So I think it's something that is unusual. I remember, though, during COVID times, there was another attorney who ended up swearing at a judicial officer. It was the case was held, and it was a virtual video. That's how it was held. So it's not usual. I don't know what the LPC will do about it, but I just wanted to say something about the exchanges that we used to see before Mr. Tobane came in. They are less than that, and Mr. Titi Tobane has been working with Advocate Mshololo in a good way. So there has been movement, but it now brings us back to when there was the first legal practitioners for advocate for accused 1 to 4, where there was a lot of exchanges, and now we're seeing them creeping back again. So it's not usual, and it's not expected for us to behave in such a manner when it comes to court etiquette.
Elton, someone suggested to me that legal practitioners actually do this to, I don't know, in a way, sort of bait the presiding officer, or I don't know, some kind of a tactic or a strategy. I don't know what would be the end of that particular strategy or tactic.
For me, it's like you can do that to a presiding officer, but it will just then boil down to the presiding officer will not give you leeway, even if you make that slight mistakes on your questions that you're asking. Then he will be on his toes all the time for you, just you transgressing, like making small transgressions. So I don't think it's a good tactic. But also, I want to touch on, as much as a legal practitioner needs to be respectful towards a court or the presiding officer, that is a mutual thing. The presiding officer should also, cause I could also pick up from the tone from Judge Maumela that it was also sort of half threatening to Titi Tobani, and I'm not speaking good on behalf of Titi Tobani. Yeah. And what was wrong for me in that is that if the state makes an objection, the defense is then by law allowed to respond in a certain way or to respond to that objection raised by the state. Now, in this instance, we saw that the judge did not want Titi Tobani to respond. So I think that from the judge was wrong. Maybe something else from Titi Tobani irritated the judge already. So he was already irritable at that moment when Tobani, and then they ended up. So the way Tobani spoke, it was a little bit condescending, but the judge himself is not free from also using a condescending tone with Tobani.
Yeah, you're absolutely right. Even from us as observers on the sidelines, there's definitely something for both sides, the presiding officer as well as counsel, to reflect on there, not only in as far as this exchange is concerned, but other similar exchanges in the past. Silindelo, so why were you guys kicked out once again from this court case?
Yeah, look, it seems to be a mistake. It was an error on the part of the technical directors for the public broadcaster who is providing pool feed. So what had happened is an inadvertent shot or visual of Tumelo Madlala leaving the witness box was taken or caught on camera while the judge was making his way to his chambers when we were adjourning for tea. And it was a mistake. It wasn't on purpose. However, because previously there have been issues with the conduct of the media and, very strict measures put in place because in terms of what we've been told, the safety of Tumelo Madlala is at risk, and the state had requested that he essentially testify in camera. And so it was brought to the judge that, look, this has happened. It literally was about 2 to 3 seconds of footage. And of course, this did not please the judge, and he did not understand exactly the technicalities around the fact that there is a pool feed, which is why all broadcasters happened to have this visual or have it aired. And he said that until the perpetrators were found, that he was going to kick out the entire media contingent, not just the TV broadcasters, but print, online, radio journalists were equally affected. And so it seemed that the following day, as broadcasters, we had to bring legal representatives to just state a case as to what exactly had transpired, and that the people responsible for what had happened had been found and dealt with. And so at that point, a meeting was held with the judge, the legal counsel, and the media broadcasters' legal representatives, where an agreement had been reached, because at that particular point, the issues were around the fact that it seems some constitutional rights were being infringed upon, because this trial to us is being held in open courts, and there have been several instances where the media itself, the news media, is being blamed for things that are essentially outside of our control. For example, because it's in an open court, people can walk in and out of court take pictures of proceedings, the witness, circulate them, and then we as the media are blamed for that. So it seems moving forward, as of Monday, really, there are going to be more stricter measures at the doors of the courtroom to control access. And of course, media has, moving forward, committed to abiding by the rules.
So let's stick with you, Silindelo, and talk a little bit more then about the testimony of Tumelo Madlala, particularly around what it did or did not see on the day that Senzo Meyiwa was killed, because he was one of the people inside the house. There was a bit of a focus on the people that he says, barged into the house, the intruder that he says was there, as well as his identification thereof, which seemed to me there seemed to have been some kind of backtracking this week.
So this is where the defense is really zoning in on in terms of picking those holes in the state's case or in the doc identification of Tumelo Madlala by accused number 2, Bongani Ntanzi, because the defense has flagged that Tumelo Madlala, to investigators 8 years ago, could only describe the first intruder. But for some reason, 8 years later, he seems to be very sure of the identification of the second intruder. So the defense is saying, but how is this possible when 8 years ago you could only describe the first intruder and could not give a description to investigators of the second intruder? So I think what they were trying to do there is show the court that there is a discrepancy in terms of the identities of the intruders in particular in connection with those who are accused. Let's take a listen to that moment.
You pointing out accused number 2 in the court proceedings, you only did that because you saw him on the media. Here it is, it's very clear. You could not compile the so-called suspect. And according to you, accused number 2 is the second suspect who was standing by the door. According to your version, you want the court to believe.
Ngifuna ukukutshela ukuthi izathu esenza ukuthi wena ke ukhombe lo mangalo wesibili la enkantolo ukuthi lokho ukuboneke ku media mhlambe kulo amaphephandaba noma kumathebula kude kanje nama television ngokuthi kuya ngawe ke lo mkhombile la enkantolo kuye ke lo umangalo wesibili lo. Then kuya ngofakazi bakho lokubhalisela uye wahluleka ukuthi ke uqinisekise noma ucompile i-identity yakhe lo.
Angikwazi lokho kusho ukuthathela lo namanje ngisangamkhomba futhi andinawo yazi namanje ngisangamkhomba futhi ubeka khona uyazi naye so le uyikhuluma angikwazi ukuthi uyithatha.
I don't know what you are saying, where do you get it from? I'm saying that even now I can point him out because he was present in the house. As to what you are saying, I don't know where you get that from.
Elton, your comment and your assessment of Madlala, particularly as far as, his performance as an eyewitness of events that happened all those many years ago, but also his demeanor in terms of engaging when he's being challenged on what he testified to and what he had earlier said he had witnessed.
For me, Tumelo Madlala out and out is an evasive witness. He can only remember things that suits his version of the events. And I mean, if he had a problem in actually giving the police a description of the second intruder when the event was still fresh in his memory. And now, after 8 years, he can remember it very clearly that this accused number 2 is the second intruder. But when you ask him a simple thing like, how much did Netflix pay you, which is like months ago, he can't remember. But he can now, after 8 years, remember that the second accused is the second intruder. Small things. When he's asked about time, he doesn't check his watch regularly. And things that's not really material. Now, that already speaks to me that this witness is trying to sell a version to court. And also now there can be a couple of things that one looks at here. He's testifying to avoid that him being charged, or there's an ulterior motive. And already when Advocate Mshololo challenged him on the payments from Netflix and how it was paid and with whom he did share it, you can see maybe even one can now look and speculate on a financial interest that was maybe given to Tumelo Madlala to testify in a specific way. So for me, Tumelo Madlala, his credibility and reliability as a witness is already, I would frown upon it. I'm already looking at it with raised eyebrows.
Yeah. Melusi, your take?
Yes, my take is when it comes to dog identification, it's not really given much weight unless it's sourced out based on preceding identification that was done before, to a certain extent. Now, what we get here is, as it was stated by my colleague, 8 years ago, he didn't give a description with the police, but now he can identify accused too. So that is kind of a credibility finding, that how can he now remember when 8 years ago he couldn't give the description? Then we also have an interesting part, which I think will come out in the following, when the witnesses were in the house will be asked questions. There's a person who was pointed out first. His name is Zamawuse Innocent, but ironically, also his name is Innocent. So I'm interested to find out how they'll connect how Kelly's mother and I think Zandile Kumar pointed him out, because right now he was released earlier on because of the fact that they couldn't connect him to the case. Now, also, there was no identity parade of the 5 accused. So it will be intriguing to see how the state connects all that, because with the first testimony of Mr. Madlala, it's not clear exactly what happened.
Yeah. I see what you did there, Melusi, with the name of the man who had been identified, his name being Innocent. Silindelo, docket 375, despite the many instances where this has come up and has been discussed at length and its status clarified, including through a lengthy submission, a letter that explained that, you know, at the moment, just pretend this thing doesn't exist. We've not made any decisions on it, on whether to prosecute or not. But it continues to be a feature of some sort, including to the extent that questions are being asked now about the fidelity and honesty of the witness who was testifying, in light of the fact that he potentially could be an accused if that other docket is prosecuted.
Exactly. So what the defense has been doing with the cross-examination to us is saying that Tumelo Madlala has an agenda. He has an interest in ensuring that a specific version of events is accepted by the court, and he's going to stick to this version of events because according to docket 375, there were no intruders. Someone in the house, according to this docket, shot and killed Senzo Meyiwa, whether it was by mistake or not. At this point, it's still quite unclear. But we've already had the former lawyer for accused 124 blatantly saying in court that Kelly Khumalo shot Senzo Meyiwa by mistake, and there are still questions around exactly who had the gun and shot Meyiwa, because there are still accusations being made against another person in the house who is Longwe Twala. So what the defense has been saying to the court is that Tumelo Madlala has a vested interest in ensuring that these 5 men essentially take the fall, because that is what is being alleged here, that there is a cover-up taking place to really hide exactly what happened in the house. And one of the most pointed questions coming from Judge Chifiwa was to actually put it to Madlala whether he was protecting himself or anyone else in the house. Let's take a listen.
Mr. Madlala, are you testifying with an intent that your testimony should result in you not being charged?
Unikeza ufakazi ubheke ukuthi ke ufakazi bakho bizawugcina isinqumo sokuthi wena ke ungathweswa icala.
Ufakazi engimnikeza la akusikho lokho. If kuTumelo wrong naye uzoya ejele. Angekho umuntu engiprotecta at all.
The testimony that I'm giving here is not about that. If it's Tumelo that is wrong, he has to go to prison. So there's no one that I'm protecting.
Please.
In fact, that answer is one of the versions of the response to that question, where at least he just went directly to answering. There's another version, Melusi, where he actually laughs when that question is asked by Advocate Mshololo. Tumelo Madlala basically audibly laughs at the suggestion. But can that suggestion be dismissed altogether, just in your understanding of, you know, the mindset of a witness, is it not preferable that you have a witness who has no worries or concerns that, any eventuality could eventually move me from the witness box to the dock?
Yeah, I think even Mr. Hart will agree with me. We've never seen a situation where there's a current docket with a second docket having the same events, and where the same witnesses in the first docket, which in this case is docket 638 of 14, if I'm not mistaken, the same witness who are key witnesses, they are also suspects in docket 375 of 19. Now, that is why you also have possibly one of the witnesses having an interest in having their attorney being a watching brief during 638, which is the current case, so that they can, I assume, be protected in the current case, so that they know in the other case, so that they know what to look for. So we haven't seen such a situation. So when a witness is testifying, and NPA has said the last letter, they say they are waiting for the outcome of 638 of 14, and then they'll decide whether to continue with 375. Now it's like a gun is held to your head to say how you testify will determine whether we charge you in the next case. It's a very unprecedented situation. So I think a witness testifying under this situation, it will be very difficult for him to give a proper evidence, or they will possibly have an agenda to protect themselves. That's my view.
Yeah. Elton, just your sense of it. Does this hang over a witness, whether or not he believes that he has a case to answer to in the other docket? Does it continue to hang that there's not been an out-and-out clarification that says we toyed with the idea, we went down that investigative path, it leads to nowhere, and therefore that docket has no standing, is unlikely to have any standing in the future, and therefore forget about it. Let's focus on this docket that brings up certain dynamics for the witness in the witness box. Or, does this continue to hang over his head, whether or not he acknowledges that fact?
Yes, Tulas, one would need to check first, because normally under the CPA, a witness can be granted that indemnity in terms of Section 204 of the Criminal Procedure Act. Now, here you see that Tumelo Madlala, or it's not out in the public or in the public space, that they've been granted that indemnity. So obviously that guillotine of how you testify in this one can lead to either you being prosecuted or not prosecuted. So obviously, if I testify now, I will testify in such a way that I will not be indicted, whatever happens with this case. So even so, I can testify. And here now, a lot of theories can be created here. Tumelo Madlala can testify so badly that there is a credibility finding against him. And these 5 guys is acquitted. But also that his testimony cannot be used against him in the second trial or any of his the 6 other co-accused that is on docket 375. So there is an interest, and there is a lot of things that's now suddenly springing up, that's possibilities. And for me here, to say that Tumelo Madlala will answer frank and honest, I don't think he's doing that at this point in time. He's not testifying open, frank, and honest. And he's protecting something, he's protecting somebody. And also what Advocate Mshololo was trying to do is to show that, and it seems now the perception out there is that Tumelo Madlala will do anything for money, because he was so very quick to actually a best friend, a sad story about a best friend, to sell it to Netflix. So for me, is if the price is right, he will sing like a canary. And that's the perception that's out there. And one should now, it raises red flags. And for me, a judge should then now approach his evidence with caution. The cautionary rule should now be called in here.
Silindelo, take us to that, actually, that interaction and the dynamic between the witness and counsel for the defense, particularly Advocate Mshololo. There were those exchanges earlier on in the week. Just tell us about some of the main highlights that came out from their interactions.
I mean, I can say that Madlala faced some very tough questions from Advocate Zandile Mshololo, who really zoned in on many of the inconsistencies, you know, at some point calling him, you know, quite unreliable, saying that his level of reasoning, you know, was what could justify some of the poor answers that he was giving to the court, the fact that he was quite argumentative. In fact, before she started her cross-examination, she cautioned him to say, look, you're not here to answer my questions. These questions are questions coming from the court. You will respect the court and we will address each other cordially. I think also picking up some of that argumentative attitude during the cross-examination from Titi Tobane, where he was always seemingly answering questions with questions. They were butting heads on a number of issues. Several times, Judge Maumela actually had to, you know, tell Madlala that, look, you're here to answer questions. Just answer what has been asked of you, nothing more, nothing less. And one of the main points that Mshololo was really driving to us was the fact that the sobriety of those in the house is in question. She's saying that the court cannot necessarily trust or rely on the account of Madlala because we don't know how much they had to drink. And even he himself cannot tell the court how much they had to drink. But what we do know is that a photograph that was taken of the cans which were found at the crime scene indicates that only 2 cans of alcohol were found. But from Madlala's testimony himself, he had at least 3 to 4 cans of beer. So it also then, you know, leans towards the story of the defense to say that the crime scene from the onset was tampered with, it was contaminated, and essentially it was cleaned. And she's saying that because we don't know how much they had drunk, you know, none of them can actually really tell us what truly happened because their account is really of one where the people in the house were under the influence of alcohol. Let's take a listen.
We're just enjoying yourself, including yourself. You couldn't count how many cans of liquor you consumed because you were just enjoying.
Bheka-ke benisijabulisa ngisho nawe siqu sakho azange ukwazi ukuthi ubale ukuthi uphuza amakani ayingakho utshwala ukuthi benijabulisa. Uzuse kahle.
Yeah, yebo besijabulisa njengoba ngangiphuza mhlambe 3 or 4, not more than 4. That is why ngisho kanje.
Yes, we enjoy ourselves. Hence I said that I consumed 3 or 4, not more than 4 cans.
But you did not count.
Mara zangu count, kunjani?
Yes, ngizange count.
Okay.
That's correct. I did not count.
Can be more because you did not count.
Ngenza ukuthi ke lawa phuzila adlula lenani ushilo ngokuthi azange kuphela ucount. No, they're not above.
And at the time when the incident took place in this matter, when you identified the intruder, you were all drunk inside the house.
Ngesikhathi kwenzeka lesehlakala ngesikhathi ke ukwazi ukuthi u-identify yena leyo umuntu oye wangena endlini ngesilungu bathi intruder beniphuzile nonke ngaphakathi endlini. Yes, we consumed alcohol, but it doesn't mean that we were drunk.
We can't deny that.
I'll deny that because I could see other things that transpired. If I was that drunk, I could not have seen them.
Enthralling, gripping, intriguing is one thing, but will it lead to the answer to the big question, who killed Senzo Meyiwa all those years ago? Color us intrigued as we prepare for the next week of the trial into the murder of Senzo Meyiwa. Silindelo Masikane, legal experts Melusi, Xulu and Elton Hart, I've got to thank you for your time here on eNCA.